Today on Legalese, we are going to be talking about the Supreme Court's unanimous decision in Trump v. Anderson. Hey, greetings, everybody. Welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. And if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, if you want to find out more about the show, you can go head over to our homepage over at legalespodcast.com. And if you want to get notifications whenever I post any new content, and I don't just do videos here on YouTube, I also do things like articles over on Substack. And if you want to be notified whenever any new content of mine is up, all you have to do is go to legaleshow.com. There you can subscribe to our newsletter and you will get notifications conveniently sent right to you. All right. We have a hell of a lot to get to today, so why don't we just jump the fuck on in? So, as I mentioned off the top, I am talking today about the Trump v. Anderson case. And like, I realize that I am releasing this video about a day behind most people who have probably already reported on this decision. And while it's understandable why people would rush to get their opinion on this case out as quickly as possible, that's not what we do here. The reason mine takes a little longer is because this was an incredibly complex decision, and this show isn't about breaking news. It is about discussing and understanding the Constitution and constitutional law. And I want to give people a video that will really drill down into the complexities of the law and present a full picture of the opinion of the court discussed with a plain meaning. Now, I'm sure pretty much everyone is probably familiar with the background of this case, at least anyone who cares enough to be watching a video like this. But let's just refresh everyone's memory real quick. Now, this all started when the Colorado Supreme Court, in a 4-3 decision, held that Donald Trump had engaged in insurrection for the purposes of Section 3 of the 14th Amendment. And as a result, he could not appear on the Republican primary ballot, and no votes would be counted for him as a write in candidate. Now, that ruling would be stayed, as this case was taken up by the Supreme Court, who agreed to hear it on an expedited basis following a motion for leave. And now, just a little over 3 weeks after the case was heard before the court, we finally have an opinion that has been issued. Look, it's something I want to just state for the record here, because I understand how controversial this whole topic is. I want to be clear that I am not taking a position, nor am I interested in taking a position, at least here publicly on this show, as to whether or not the Supreme Court rightly or wrongly decided this case. All I'm interested in doing is breaking down this opinion for exactly what it is and discussing it with you all with the kind of plain meaning that will make this discussion helpful to lawyers and non lawyers alike. And if I'm being perfectly honest with you guys, actually, I try very hard to avoid talking about Donald Trump in any capacity. But as constitutional law really is my bread and butter, I can't not make a video discussing this case, whether I want to or not. Now, that said, uh, let's move on to talking about the case itself. Now, the final decision in this case was unsurprising to anyone who had listened to the oral arguments. It had been very clear that there had been at least 8 votes to overturn the Colorado Supreme Court on some theory that the state of Colorado or any state didn't have the power to exclude eligible candidates from their ballots for various structural and practical reasons. It was really only going to be a question of which of the several different lines of reasoning the court would choose to follow. Now, this opinion was broken down into several different sections. Section 1 is just a recounting of the facts of the case and the procedural history. Now, Section 2A was a discussion of who can enforce Section 3 and in what context is it appropriate for them to enforce it. Next came Section 2B, which would explain why the actions of the Colorado Supreme Court in particular were not consistent with Section 3 of the 14th Amendment. And then finally, there were two concurring briefs filed in this opinion, one by Justice Amy Coney Barrett and another one filed jointly by Justices Kagan, Sotomayor, and Jackson. Now, while we will be briefly touching on Section 1, I am actually going to mostly skip this because, I think anyone who is informed enough to be watching a video like this, for you, the facts are already probably pretty well known. Now, after that, we are going to actually start with Section 2B because that is the part of the opinion that all nine justices were in complete agreement on. After that, we will be moving on to discussing Part 2A, and this part is one in which Justices Barrett, Kagan, Sotomayor, and Jackson did not join the majority. And then finally, we will be discussing the concurring opinions from those justices to explain why they didn't concur with Section 2A. Now, I think perhaps the first thing to note here about this case is how they chose to issue the holding per curiam. Now, this simply means that the opinion was delivered as an opinion of the whole court and not that of a single judge who was writing on behalf of the other members of the court in agreement. And perhaps I shouldn't speculate too much here, but it does seem pretty clear to me that the actual author of this opinion was Chief Justice Roberts, just from a purely stylistic standpoint. But the big thing is the fact that they issue this holding with one voice, I think is very important in driving home the fact that the decision the court reached, whether you agree with it or not, was a decision based on the law and not as many people assumed it would be, and as many people will probably continue to assume it was not a politically motivated opinion. The fact is that even the liberal justices would agree with the part of the holding that said you can't take Donald Trump off the ballot on Section 3 grounds. Now, just for a quick refresher, let's take a look at exactly what Section 3 of the 14th Amendment actually says. So it says no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of two-thirds of each house, remove such disability. So let's start with a discussion about Section 1 of this opinion. Now, the case starts with a quote from the case State Limits Incorporated versus Thornton, which was a 1995 decision that ultimately said that states have no power to add additional qualifications for congressional candidates such as term limits. Now, from there, it would cite Justice Joseph Story and his commentaries on the Constitution to say that if states are exercising power in federal elections, that power must come from some source in the Constitution. And so the quote here from U.S. Term Limits Incorporated says, our Constitution leaves some questions to the states while committing others to the federal government. Federalism principles embedded in that constitutional structure decide this case. States cannot use their control over the ballot to undermine the national government. Now, they would further elaborate on the fact that on the fact turning to Anderson v. Celebreze, which is a case that said, among other things, that the danger of states jeopardizing national governments essentially is even greater in the context of a presidential election. Now, while we have discussed on this show many times that the states do, in fact, actually hold a considerable amount of power over the election of a president, as evidenced by the Chiafalo case, which said that no doubt states have significant authority over presidential electors and, in turn, presidential elections. But that power is limited by other constitutional constraints, including principles of federalism. Now, state restrictions in that context implicate a uniquely important national interest extending beyond a state's own borders. And so, in accordance with Term Limits Incorporated, we need to ask if you are looking at Section 3 of the 14th Amendment in terms of a presidential election, where is that power coming from? Now, the court holds that it can't be the 14th Amendment, since that amendment is actually a constraint on state power. Also, Section 3 and Section 5 of that amendment both give power to Congress to enforce their provisions, and Congress alone. So, the fact is that this enforcement power that Colorado claimed, according to the court, cannot come from the 14th Amendment. And looking through the rest of the Constitution, you find that you simply don't find it. Now, Article 1 and Article 2 deal with the congressional and presidential elections, and they do give the states some power over the time, place, and manner of holding those federal elections. But nothing in those federal function powers given to the states in Article 1 and 2 gives any indication that these states can come back and find some power, find any power really, to enforce Section 3 of the 14th Amendment. So, with this in mind, let's turn to Section 2B of the opinion to see how the court used these principles in their constitutional construction. So, again, when we talk about Section 2B, I want to remind everyone that this is the part of the opinion that all nine justices would sign on to. Now, their decision in this section was looking at this issue through a mix of text, structure, and context. So, as a structural matter, this provision, being Section 3, is one that is designed for congressional enforcement, congressional remedies, and congressional mechanisms. And the court would hold that, as a practical matter, it makes very little sense for states to add these sorts of burdens on presidential candidates. While the court says that if they wanted to do this for state candidates, that's their own thing, but to do so for a presidential election, they hold really doesn't make any sense. Now, additionally, one state's evidentiary laws or their procedural mechanisms will certainly vary from other states, and that means that these sorts of challenges could have a very odd ripple effect, wherein, if the provision was a power granted to the several states, it would lead to inconsistent results throughout each of these several states, which also makes no sense when you are talking about a provision in the federal constitution. So the court would say that conflicting state outcomes concerning the same candidate could result not just from differing views of the merits, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. Some states will allow a Section 3 challenge to succeed based merely on a preponderance of the evidence, while others might require a heightened showing. Now, ultimately, what the court would hold in Section 2B was that, to the degree this case raises the question whether the states, in addition to Congress, may also enforce Section 3, that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices and especially the presidency. And the court would note that such a power would flout the principle that the Constitution guarantees the entire independence of the general government from any control by the respective states, according to Trump v. Vance and an earlier case, Mechanics Saving Bank of Minneapolis versus Minnesota. Now, so far, this has been a very clean and logical decision, and it would have been fantastic had the court stopped right here, but for some reason, they didn't. So, moving on to Section 2A, 2A was really quite peculiar as it was looking at who else would have the power to enforce Section 3 and in what context they could enforce that power in which it would be properly applied. And this section speaks about how Congress has a role to enforce the provisions of Section 3 and Section 5 of the 14th Amendment, and that it provides them the power to enforce this through appropriate legislation, but that, in accordance with the precedent set in Bernie v. Flores, quote, it must be a congruent and proportional to the remedy of the concerns that are addressed by these provisions of the Constitution, end quote. So they are saying that when Congress steps in to enforce this provision, that it must provide this sort of remedial scheme. So, for example, when we are dealing specifically with insurrection, it does require the ascertainment or requires a determination of whether or not someone actually engaged in insurrection, which requires proceedings and factual findings. Now, this is also what Justice Chase would say in a case that the court, the majority at least, would largely rely on in their decision for Section 2A. This is Griffin's case. And this case occurred in 1869, 1 year after the ratification of the 14th Amendment. And in this case, Justice Chase was essentially, he was, Justice Chase was riding circuit as a circuit court justice in 1869. And in this capacity here, he was as a federal judge overseeing a habeas hearing. Now, during the habeas challenge from Griffin, who had been convicted in a West Virginia state court, he challenged his conviction in a federal court because he said that the state court decision was adjudicated by a judge who Griffin claimed was barred from holding office under Section 3 of the 14th Amendment. Now, Justice Chase said that he was not in a position to make a determination on these issues, in part because such a requirement would require a judicial determination from proceedings, evidence, ruling, and enforcement of this provision. And Chase would go on to point out that these are indispensable, and furthermore, that unless he is given such guidance on these matters by Congress to figure out what to do here, his role as a judge in adjudicating this as a matter of law was simply not possible. So I want to move on to the four key takeaways from the majority opinion in Section 2. So the court in this per curiam opinion would essentially make four primary moves. Now, first, the court would agree with Justice Chase's opinion in Griffin's case The Congress must establish the procedures to enforce Section 3, and they say, quote, it is therefore necessary, as Chief Justice Chase concluded, and the Colorado Supreme Court is self recognized, to ascertain what particular individuals are embraced by this provision. And Chase went on to explain that to accomplish this ascertainment and assure effective results, proceedings, evidence, decisions, and enforcement of this decision, which were more or less formal requirements, are indispensable. So, second, the states this case found have the reserved power to disqualify state officials, but states have no power to disqualify federal positions. And turning to the per curiam opinion, the court said, we conclude that states may disqualify persons holding or attempting to hold a state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, and especially the presidency. Although the 14th Amendment restricts state power, nothing in it plainly withdraws from the states this traditional authority. And after ratification of the 14th Amendment, states would use this authority to disqualify state officers in accordance with state statutes. And they cite a number of precedents to drive this home, including Worthy v. Barrett and Sandlin v. Watkins. And they close by saying that such power over governance, however, does not extend to federal office holders and candidates. Now, third, they say that the legislation to enforce Section 3 must satisfy the so called congruence and proportionality test that comes from City of Bourne v. Flores. Now, the court suggests that the Electoral Count Reform Act does not meet this test, and in fact, that the court suggested that Section 2383 would be a valid enforcement legislation. And turning to the opinion, the court said, quote, any congressional legislation enforcing Section 3 must, like the Enforcement Act of 1870 and Section 2383, reflect congruence and proportionality between preventing or remedying that conduct and the means adopted to that end, and that neither we nor the respondents are aware of any other legislation by Congress to enforce Section 3. All right, fourth, and finally, under Anderson v. Celebres, there are distinct interests in having a uniform system for electing the president. And again, turning to the per curiam opinion, the court says, finally, state enforcement of Section 3 with respect to the presidency would raise heightened concerns. In the context of a presidential election, state imposed restrictions implicate a uniquely important national interest. But state by state resolution of the question of whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represents all the voters of the nation. And conflicting state outcomes concerning the same candidate could result not just from differing views of the merits, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. And with that, let's move on to discussing the two concurring opinions in this case. Now, as I mentioned earlier, one was authored by Justice Amy Coney Barrett, and she pretty much just says that she concurs with Part 2B and that it wasn't necessary for the court to go any further to reach their decision in this case, and she therefore chooses not to sign on to Section 2A. And turning to the opinion, she says, quote, I join parts 1 and 2B of the court's opinion. I agree that states lack the power to enforce Section 3 against presidential candidates, That principle is sufficient to resolve this case, and I would decide no more than that. This suit was brought by Colorado voters under state law in a state court. It does not require us to address the complicated question whether federal legislation in is the exclusive vehicle through which Section 3 can be enforced. Now, in the concurring opinion by Justices Kagan, Jackson, and Sotomayor, they basically say the same thing, but with some pretty harsh and critical language that helps to elaborate on this point. So they start with a quote from Dobbs v. Jackson's Women's Health Organization that was actually penned by Chief Justice Roberts that says, quote, if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. And they say that this fundamental principle of judicial restraint is practically as old as our republic, that this court is authorized to say what the law is only because those who apply a rule to particular cases must, of necessity, expound and interpret that rule. And so they would contend that in Section 2A, the court would depart from this vital principle, deciding not just this case, but challenges that might arise in the future. Again, turning to the per curiam opinion, they say, in this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the grounds that he is an oath breaking insurrectionist and thus disqualified from holding federal office under Section 3 of the 14th Amendment. Allowing Colorado to do so would, we agree, create a chaotic state by state patchwork at odd with our nation's federalism principles, and that is enough to resolve this case. Yet the majority goes further, even though all 9 members of the court agree that this independent and sufficient rationale will resolve this case, yet 5 justices continue to go on. And they say that this court continues on to resolve questions not before us in a case involving no federal action whatsoever, and the court opines on how federal enforcement of Section 3 must proceed. Now, in this concurrence, the justices would say that the court's majority opinion and its musings about Griffin's case are as inadequately supported as they are gratuitous. They go on to suggest that Section 3's text doesn't say that this provision is one of congressional enforcement alone, and they point out that other provisions of the Constitution, including other provisions of the Reconstruction Amendments, including the 14th Amendment's Due Process Clause and the Equal Protection Clause, don't require additional congressional implementation through legislation, and that these provisions are seen as self enforcing. And the justices worry that this broader opinion that the court has written will be applied in the future, whether or not they are adding legitimate constraints on how Congress goes about enforcing Section 3 and prohibiting other actors from enforcing Section 3. And the justices give one concrete example, which is that this opinion forecloses judicial enforcement of Section 3, such as might occur when a party is prosecuted by an insurrectionist and raises a defense on that score, with the notion being that without congressional implementing legislation, if you have someone who has taken an oath to the Constitution who goes on to engage in insurrection and is now serving as a judge, it would be impossible for someone to raise a defense to say that this judge is not qualified or authorized to hold office, save for existing congressional legislation that would almost act like a bill of attainder. Now, in closing, I think it is perhaps worth mentioning a number of issues that the court did not address in this case. Now, these were mainly factual issues, such as whether or not January 6th was an insurrection, whether Donald Trump engaged in insurrection, or whether or not his speech that day was or was not protected speech under the First Amendment, or whether his conduct was protected conduct. Also, none of the justices would address the office and officer related arguments, despite a great deal of interest in understanding and incorporating those arguments that came from Justices Gorsuch and Jackson during the oral arguments. So, one thing that is clear here is that this case really closes the door on any other ballot challenges going forward, be it in the primaries or the general election. The court is quite clear that there is no role for the states to enforce this provision. There is simply no affirmative enforcement authority given to the states as a result of Section 3. But another thing that, at least to me, is clear is that Section 2A of the opinion that talks about appropriate and tailored remedies by Congress through proper enforcement legislation where the remedy needs to be narrowly tailored to the harm does also seem to put to rest any post election challenges that could arise as well. And this is not just hypothetical. This would suggest that future challenges under the recently passed Electoral Count Reform Act, passed as a reactionary measure to January 6th by Congress, wouldn't suffice. And I think a careful reading of this opinion would also lead one to the conclusion that challenges to agency activity under Section 706 of the Administrative Procedures Act would be improper insofar as suggesting that appointees to administrative agencies lack the authority to serve because they were appointed by someone who has been found to be ineligible for public office. Now, these particular issues are far from settled, but I think that this opinion certainly chills any attempt to reach the same disqualification through those other means that we already see people trying to utilize. All right. Well, that is all I really have for you guys today. Thank you so much for tuning in to Legalese. If you would take a moment and do all of those things that help to trigger Al Gore's rhythm, I would very much appreciate it. If you like the video, go ahead and hit the like button. If you disliked it, you can hit the dislike button, though I would prefer the former. Also, don't forget to subscribe to the channel so you always get notifications whenever I put out new episodes. And yeah, I guess really all that's left is to sign out. And this has been Bob for Legalese, talking about Trump versus Anderson. And of course, as always, Cartago delenda est.